Senator Moore.
Thank you, Mr Acting Deputy President. I'm not going to respond to Senator McDonald's last statement. He keeps making these statements across the chamber, and it does not add to the quality of this debate. We have had a number of senators talk about the history of this piece of legislation. We know that the bill before us is an amendment bill. It was introduced into the government by the government in the other place early this year, 15th of February. That was the first time that this bill appeared in this parliament. It amends the original Native Title Act to resolve uncertainty that was created by the decision of the full federal court in what we've heard many times now. It was the McGlade versus Native Title Registrar. That decision was handed down on the 2nd of February this year. I think, Mr Acting Deputy President, all of us in this place understand the importance to our community, to our culture, of the native title legislation. In fact, some of us remember exactly where we were when that original legislation was passed in 1993. I know that in the community in which I was working at the time, we were waiting to hear what was going to happen after that extraordinarily long debate, which I think probably is still one of the longest debates in this place, where finally we had established as a parliament in Australia to ensure that there was native title legislation in our community. So this is a very, very important piece, groundbreaking legislation, native title legislation. Before us we have an amendment to that, and that must have fulsome and true consideration, and there should not be, by any sense of urgency, a push in this place to rush things through. Having said that, Mr Acting Deputy President, I think that we are doing the right thing. We are, through the parliament, considering the legislation after the process of it being introduced, coming to the Senate, after a bit of a flurry here, getting the Senate selection of bills to ensure that we did have a hearing on the piece of legislation, which was an essential part of the process. The Senate doing its job through the Legal and Constitutional Committee to review the legislation, to hear from people who, again, people and organisations that gave of their time, their professionalism, their knowledge and experience to come to the Senate to give us their views on the legislation. And I think there have been a number of contributions both in this debate and also in questions earlier today, which may have seemed to indicate that at that Senate inquiry there was a unanimous view put forward, that every person who came to that inquiry agreed that this amendment bill needed to be passed and needed to be passed urgently. Well, that's not true, Mr Acting Deputy President. As with most of the Senate inquiries in which I've been involved, there was a wide range of opinion brought to the Senate committee. The Legal and Constitutional Affairs Legislation Committee brought down their report, and in that report it did reflect that there was a wide range of views put before the committee. But as we've been told in previous contributions, the Labor senators, Senator Dodson and Senator Pratt, actually accepted, on the basis of the evidence, that because of the specifics of the McGlade legislation and how it had impacted on native title, McGlade decision, how it impacted on native title, there was a need to ensure that there was a response from Parliament to stop any uncertainty or confusion. However, as we've heard from other contributions, this was only step one of the process, Mr Acting Deputy President. There was a need for further discussion, and we've heard how Senator Dodson and Senator McCarthy were able to talk, and Mr Dreyfus were able to be involved with future discussions. Only then did more amendments appear, which I understand, Mr Acting Deputy President, the latest amendment that's part of this discussion only appeared to the Parliament yesterday. So it is not such a straightforward process as some would make us believe. But in terms of what caused the legislation to be before us, Mr Acting Deputy President, we know that following the bringing down of the Keating legislation, the Native Title Act in 1993, we actually enshrined in legislation the decision of the High Court of Australia in Mabo versus Queensland, my state, which had held that the doctrine of terra nullius did not apply when there were already inhabitants present. Again, the importance to our community of the High Court decision followed by the response to that decision by our Parliament must always be kept front of any discussion we have about amending the legislation. To make it clear, and this was put through, and I'm actually quoting now from evidence and discussions that were put into the Legal and Constitutional Affairs Committee, following the Mabo decision, any Indigenous land rights which had not been extinguished by the Crown continued to exist in Australia. Since 1993, the Native Title Act has enabled the continued recognition and protection of Indigenous land rights. It's Labor's view, and it has been clearly enunciated by previous speakers from Labor senators, that any changes to the Native Title Act must be properly considered and consulted on with Indigenous and Torres Strait Islander communities. Mr Acting Deputy President, that is a key component of our commitment to our Indigenous, to Aboriginal Islander communities, that no decision that impacts on their culture, their land rights, and in particular this particular process that talks about their future, the whole future of their relationship with land, none of those decisions can ever be taken without full and proper consultation. And that's something that this Parliament should enshrine in the processes they put in place. The Native Title Act provides a legislative process for native title groups to negotiate with other parties to form voluntary agreements in relation to the use of land and waters, referred to as the Indigenous Land Use Agreements, the ILUAs, which people use as a shorthand way of defining these agreements, and that was defined very clearly for us in the evidence that came to the committee. Currently, under section 24CD of the Act, all persons in the Native Title Group must be parties to an area ILUA. I say ILUA, I've heard it done as ILUA, but if there is a registered Native Title claimant for the purposes of the Act, the Native Title Group consists of that registered Native Title claimant. A registered Native Title claimant is defined again in the Act under section 25(3) as, and I quote, a person or persons whose name or names appear in an entry to the Register of Native Title Claims. This enables a person or persons to enter into agreements as authorised by the Native Title Group. The McGlade decision found that an area ILUA could not be registered unless all members of the registered Native Title claimant were parties to that agreement, unless all registered Native Title claimants had signed the area ILUA, including members of the group who may have died. This ruling overturned the decision that had been current and on which a range of decisions had been made, the ruling of QCG Proprietary Limited versus Bygrave, No. 2, 2010, which found that an area ILUA could be registered if it had been signed by at least one member of the registered Native Title claimant group. Post-McGlade, the only alternative available to a registered Native Title claimant group is to reauthorise a new applicant and make an application under 66B of the Act to remove any member of the group who refused to sign. Stakeholders have indicated that this process can impose high costs on registered Native Title claimants and cause delays. There was significant evidence to the committee, Mr Acting Deputy President, that this could cause confusion and it could cause worry in a community if they had to go through the whole process again of registering and then waiting for the process to go through the courts. And that was the evidence that came to us that asked that there needed to be consideration made to approve the amendments that are in this legislation that we're debating today in the Parliament. This decision, the McGlade decision, has potentially far-reaching implications for approximately 126 existing registered ILUAs that had been made in reliance on the decision in Bygrave over the past 7 years. So these decisions had been made, discussed in the communities and then registered with the Register of Native Title Claims. So they had been finalised in good faith, and subsequent decisions had been made about rights to the use of land, about the opportunities that existed in communities based on that agreement. The ILUAs include agreements concerning very large areas of land across Australia, including ILUAs made with respect to national parks, agricultural ventures and mining ventures. This bill responds to the McGlade decision by amending the Native Title Act so that any area ILUA which was authorised and registered prior to the McGlade decision will be valid, despite not being signed by all members of the registered native title claimant group. We have been advised by the government that this change to the law will ensure the validity of approximately 126 registered ILUAs that were negotiated in good faith by native title holders with land users on the basis of the law as it was clearly understood to be. These amendments, the ones we're debating, will also enable the registration of area ILUAs that were lodged for registration prior to the McGlade decision, despite not having been signed by all members of the registered native title claimant group. Again, from advice from the government, it says this will apply to a further 8 ILUAs. The further amendments, and this is the point, at the time that the Senate Legal and Constitutional Affairs Committee met, the discussions that were held at that time and the subsequent discussions that were held in weeks later did not, that was the end of the information we had and the basis on which the Labor senators agreed originally to accept and support this Native Title Amendment Act. But subsequent to that, Mr Acting Deputy President, another series of amendments have come before the Parliament, and those that have been proposed to consider the situation of the Cape York Land Council, which would extend the bill to also validate area ILUAs that could otherwise be rendered invalid if successfully challenged in the federal court on the basis that they were not signed by any registered native title claimant. This is another complication, and in terms of the principle, there is still the situation that we need to make quite clear so that people fully understand their rights and fully understand the implications of the decisions that we're making in the Parliament. But, Mr Acting Deputy President, that information was not available to the Senate Legal and Constitutional Affairs Committee when they met. It was not available to people who were looking at what was going on in the Parliament up until this week. And again, Mr Acting Deputy President, this creates, I think, a sense of urgency that was not effectively discussed and understood before the last period of discussion. Despite that, Labor has listened to the arguments put around the situation in the Cape York Land Council and the situation about their particular leases in that area, and we have agreed, it's my understanding we have agreed to approve to that process as well. But this, Mr Acting Deputy President, reinforces the concerns that have been raised by people in the community about the need for full consultation and understanding a process. I accept, Mr Acting Deputy President, that we will never be able to fully please every person who has some ownership in this case. There will be differences of opinion. We see that and we must acknowledge that. But that almost gives a greater cause that what processes are in place, how we are proceeding, and the basis on which we are proceeding must be adequately explained and understood. And that is my concern, that if we don't actually fully commit to that principle and understand the sensitivities, that could impact on not just this case, but cases into the future. So, on the basis of the evidence that's before us that has come today to our consideration for this particular bill, we believe that there have been cases made in terms of the urgency and the need to ensure that there is no confusion in community or in the various property or business processes that are taking place through agreements that have been made prior to McGlade. We understand the need for that. But I think that we have to, at the same time, make it very clear about our concerns about any perception that this has been rushed, any perception that people have not had their rights and their culture fully understood and accepted and respected. And we need to make a commitment that we understand the concerns that have been raised about consultation, and we understand that any future action that this Parliament takes will take will respond to those sensitivities and will respond to the understanding that full consultation will take place. Because, Mr Acting Deputy President, this is unfinished business. We know that there will continue to be further need for changes, for amendments to the native title legislation. As we know, our Shadow Attorney-General, Mr Dreyfus, when he was Attorney-General, did refer issues around native title legislation to the Australian Law Commission to fully consider where we are now with this legislation and changes that will have to take place into the future. We need now, well, certainly that particular law report needs to be fully considered by government, and I think that will mean that there must be much further discussion in this place and a clear process put in place for how we will enshrine the consultative process into the future. Because, Mr Acting Deputy President, we need to make sure that there is trust in the way the Parliament will respond to the Aboriginal Island communities. That was the intent of the 1993 process. It was the intent of the High Court decision that there was an understanding, a clear understanding and a commitment to the principles of native title legislation, of true ownership of land. We need to absolutely ensure that into the future, in any discussions about native title, that trust is there and that there is an understanding that we will put in place appropriate and agreed consultation processes. If we don't do that, we are destroying the history and the challenge of native title. If we don't do that, we will be not fulfilling the extraordinary work that was put in place by the Mabo process, by the Mabo family then and now, who continue to be actually in many ways the custodians of the native title legislation. So, Mr Acting Deputy President, at this time, Labor is supporting the legislation, but we actually say that we can do the processes better, and we must do the processes better. Anyone who's listened to the contribution made by Senator Dodson would understand the way that we can do this better. I know Senator McCarthy will be making the same comments into the future as she's made today about what we must do, and I think that that should be what should be one of the processes that come out of today's debate. Looking at today's legislation and the amendments which we are supporting, but learning from the process to ensure that this negotiation, this discussion cannot be rushed. We need to ensure that consultation takes place. We don't need to have cracks across this chamber saying that the process of having full debate in this place is determined by whether senators want to have a long weekend or not. Mr Acting Deputy President, that does no honour to the person who makes those comments, and it certainly doesn't reflect appropriate discussion in this Senate. No one owns morality. No one owns best practice, but we can do better than exchanging barbs in that way. What we must do in the Parliament is look at legislation, listen to the people who have knowledge and experience and ownership, and then balance the arguments here, openly debate the process and move forward, bringing people together rather than laying down laws upon them from outside. And, Mr Acting Deputy President, if we do that, we'll continue the message of Mabo, we'll continue the message of the Keating legislation from 1993, and we will enshrine true native title in this community together rather than divided.